provides for this. The one which all police officers are very well aware of is the section 91 of the Criminal Procedure Code. That is the one that they often use in other, let's say, crimes. And even in the cyber crime, when it comes to cyber crime, this we find is a section which is most often used by the police officers. The other ones are Section 69 of the Information Technology Act, Section 69B of the Information Technology Act. Then there are various mutual legal assistance treaty between countries which help in getting information. Then there's a Cloud Act in the US. I'll touch upon it. I mean, we can't go into detail because of the time constraint. I will touch upon that. And then there is the Budapest Convention, which India is not a signatory. Okay, let's start with the most important section, that's section 91. And before that, let's see how the intermediate is fair as far as providing access to law enforcement agencies is concerned. We get these details from the transparency report provided by Facebook, Google, etc. Even Microsoft has a similar transparency report. Now, if you look at the data available for the period from July to December 2019, Facebook had asked, Facebook received more than 24,000 requests for user data from the government in India. And of that, they produced data in 58% of the cases. And if you look at Google, for the same period, there were more than 10,000 requests for pertaining to 25,000 odd user accounts. And in this, 62% the data was produced. Let's look at the legal provisions. One, the section 91 of the CRPC, which I said earlier, is the most commonly used provisions used by the investigation officers, investigation agencies. This is a general provision which provides them the power to ask for information. This could be by a court, could be by the investigating office. We have even seen cases where they even ask for takedown of content which is fed beyond the provision, but we have seen that also. In many cases, even takedown of content is asked by this provision. This is what they often use. So yes, one of the most important provisions, Section 69 of the Information Technology Act. This gives the central government and the state government powers to ask for interception or monitoring of data, or even decryption of data. This is something akin to the powers under the Telegraph Act for telephone tapping. We have also rules laid down under Section 69, which specifically talks about who has the power to order such, let's say, requests for getting data, for ordering decryption. For example, if the investigating officer wants access to Gmail, somebody's email, a suspect's email, then you can use this route. You can even ask for decryption of information, provided that, of course, that the entity has the provision to decrypt that data. So all these powers are available under various provisions of the IT Act. Then the section 69B of the IT Act, this is more with respect to the metadata. So to give an example, if you look at your, let's say, telephone calls, even if you don't get access to the content, if you get access to details like whom you are talking with, the number of, let's say, the time that you spend for each call, for that cell tower location, you get a whole lot of data. Now, Section 69B is something similar to that, where you get metadata. For example, you get access to the IP information. If you are asking this information to your internet service provider, they will give you the IP information. This is not a content of, let's say, email and things like that. Section 69B is about the metadata. So the data about that content. You don't get access to the content, but then you get access to the entire metadata. Okay. So that's about the Indian legal provision. Now, the Cloud Act is used in the US. The reason, if you look at the history of why the Act, let's say provide investigation. Access to email stored in Ireland. There was a suspect, so there were FBI wanted access to Microsoft is stored in the server of the investigating agency, and that they cannot give access to these email servers. So the Cloud Act was an answer to that, which provided these intelligence agencies, investigation agencies, access to data, even if it's hosted in another country, the servers located in other countries. Now, why should this be of interest to other countries? It's because this has a provision to have executive agreement. So, a country like India can have an executive agreement. Just doing it, it has to be approved by the Attorney General in the US, and there are various considerations for that. Like, for example, the legal system in India, it should be of the laws involved. All that is there, but yes, this provides a provision to access data which is stored in the US, let's say by the and the method of doing this is through the Cyber Crime Convention or the Budapest Convention. There are 67 signatories to this convention. The idea is to have cooperation among various countries. The problem adopted when you have a cybercrime or cybercrime investigation is to rely on the MLATs, that's the mutual legal assistance treaties between countries. But this is often a very slow process, and you find it very difficult to get information. For example, let's say if there's a terrorist attack happened, something like what happened in the case of Christchurch in New Zealand, you need a fast access to information. You cannot go through this MLAT process, try to get information, and which could take for maybe for days and weeks. So this is the idea of Cybercrime Convention, Cloud Act, etc., is to ensure that there is a faster process. But there are some issues with the Cybercrime Convention. There's a reason for India not signing to it. There are conflicting opinions. Some say that India should sign with, when should become a signatory. Then there are others who say that because of some specific clauses with respect to Copyright Act, it is definitely a valid objection. I mean, it's not proper for India to sign the Budapest Convention. Okay. Now the most important part about the jurisdiction of Indian courts. So initially we were discussing about the investigation. What are the issues that law enforcement agencies, investigating officers find when they try to access information, as far as servers of intermediaries, servers of various companies are hosted outside Indian jurisdiction. That was the first part that we discussed. Now let's look at the jurisdiction of Indian courts. See, we don't have a long-arm jurisdiction law as such, but various statutes like the IT Act, CPC, IPC, they have certain provisions which could be considered as long-arm provisions. This gives the court jurisdictions to try cases involving persons not residing in India. This has been debated a lot, whether, in fact, even these laws have long-arm jurisdiction. But yeah, that is a much more broader debate as that. Now, look at the provisions of Information Technology Act. Section 1(2). The Act says that the Act shall extend to the whole of India, and save as otherwise provided in this Act, it applies also to any contravention that are committed outside India by any person. That's one of the clauses which provides for a long-arm jurisdiction. Yeah. Then, most important one is the Section 75 of the IT Act. It says that Act applies to any offence or contravention committed outside India. So, it's subject to the provision of subsection 2. The provisions of this Act shall apply to any offence or contravention committed outside India by any person, irrespective of his nationality. Now, for the purpose of this subsection, the Act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting the offence or a contravention involves a computer, computer system or computer network located in India. So the condition is that there should be a computer, network, or resource which should be located in India. Maybe the person is located outside India, but where the crime happened, if the computer is based in India, is in Indian jurisdiction, then yes, the long-arm jurisdiction, the long-arm process of IT Act would apply. Let's see how the courts have dealt with this complex issue of jurisdiction in India. One of the first cases is the Cashew India was Ashida Telesystems. There the court held that if there's a website which can be accessed from Delhi, that is sufficient. This has changed over a period of time. I mean, most websites for that matter would be accessible throughout the world. So if you're going to allow jurisdiction, the courts to take jurisdiction just because of that, then it could be really be problematic. There was a change in the legal position with the India TV versus India Broadcast Live case, where the court held that personal jurisdiction cannot be exercised over non-residents merely because their website is accessible within the jurisdiction of the court. There has to be something more to indicate purposeful direction of activity to the forum state in a substantial way. So, there the court held just because a website is available, let's say in Delhi or any part of the country, that doesn't mean that courts in that jurisdiction can decide the matter or can adjudicate the matter, because otherwise it will be very problematic. So, in a way, the website is accessible across the country. That doesn't mean that any court in any part of the country can decide it. The idea was that there should be some uh, action from the part of the defendant to direct its activities towards, let's say, one area. For example, if you are targeting customers in Delhi, then yes, the Delhi court would have jurisdiction. Otherwise, not. Then this is the most important case, which has gone into all this jurisprudence across the country. I mean, across the world. So this, by the division bench of the Delhi High Court, this is the most important case as far as the jurisdiction issue is concerned in India. Banyan Tree Holding versus Murali Krishna Reddy. So the matter related to passing of action. Banyan Tree Holding it was a hospitality company in Singapore with business ventures across the globe. They were using the mark Banyan Tree in its business transactions, and they had, I mean, since they had used it over a long period of time, they had, of course, rights over the trademark. But their application was still pending. So this was not an infringement matter. This was a passing of suit. In 2007, what happened was that a Hyderabad-based township developer, they started a project calling it the Banyan Tree Retreat, and this was challenged in court, saying by Banyan Tree Holdings as passing off their trademark. Now, what the court held was that for the purpose of a passing of action or infringement action, where the plaintiff is not carrying on business within the jurisdiction of a court, and in the absence of a long-arm statute, now to satisfy the forum that it has jurisdiction to entertain the suit, the plaintiff would have to show that the defendant purposefully avail, this is important, purposefully avail itself of the jurisdiction of the forum court. For this, it would have been prima facie shown that the nature of the activity indulged in by the defendant by the use of the website was with an intention to conclude a commercial transaction with the website user, and that the specific targeting of the forum state by the defendant resulted in an injury or harm to the plaintiff within the forum state. So, the court devised three main tests to determine the question of jurisdiction. One was the purpose availment test. That is, there should be if you look at the activities by the different, there should be a purposeful availment of the jurisdiction. That is, there should be something, let's say, even if it's a website, whether they allowed whether they try to canvass customers from that region, whether there was any commercial transaction with users in this region, where the forum is based. Then the second one was the sliding scale test. Third one is the effects test. The sliding scale test is on the basis of uh, the interaction on the website, whether it was just a static website or whether it was a dynamic website allowing for users to enter information. What were the various factors as far as the website is concerned? It was more on the nature of how much the customer can interact with the website, and also the kind of information collected and things like that. So that is a sliding scale. So you have to think of a so if the activities on the website, the interactive nature of the website is of such a nature that uh, there's an option for the customer to enter into a sale. We provide information and things like that. Then yes, there is concern, like some interaction between the customer and there's the website in that jurisdiction. Then third one is the effects test, where you try to understand the effects as far as uh, the place is concerned. What is the effect of interacting with the website? What was the website trying to do? And this is often used in defamation cases. For example, if you're, uh, let's say, if there is a post on Facebook, which is read widely by maybe a person who's based out of Tamil Nadu. The website is available across the world. But the effects were, since this person, the plaintiff is based out of Tamil Nadu, and uh, the effects of this defamatory post was felt mostly in this area because he's based there, and this is where the most harm was done. The effects were in that jurisdiction. So this test could be used to figure out what the effect of this transaction on the website. Especially in defamation cases, this test is used a lot. Figure out where the jurisdiction lies. Now, this is something which has happened recently uh, with respect to takedown orders, where takedown orders are given for content across the globe. Usually, when you have takedown orders, this again has a reference to Shreya Singhal, where Shreya Singhal laid down the law as far as intermediary liability is concerned. The court said that you can, let's say, intermediary like Google or Facebook, they have a safe harbor protection, that they enjoy protection from user generated content. Even if you write something maybe defamatory on Facebook, Facebook cannot be held liable for that content. They can be held liable only if they don't take down the content even after getting an order from the court. This is post Shreya Singhal. Shreya Singhal, the Supreme Court held the website, the intermediary need to take down content only on receiving an order from the court or from the appropriate government agency. Now, with the global takedown, the issue is that if you look at the specific case, that's Ramdev versus Facebook, this pertained to a book which was considered to be defamatory, which was on Baba Ramdev. There were some Facebook posts which are also related to this. The court held these also to be defamatory. But the problematic part was the content was asked to be taken down not just in India, but across the world. The court held that once the content was uploaded from India and was made available globally, the removal of such content shall also be worldwide and not just restricted to India. Now, this can definitely be a problematic situation. Because I mean, the way the internet operates, if the most regressive countries go for this kind of an option, the free speech standards differ across the world. And think of countries, maybe autocratic countries, which have the worst, record on free speech. If their rules are to apply for this kind of a content, then you will have the free speech standards of the most regressive country across the world. So this, I'm not sure what's the status of the appeal filed by Facebook in this matter yet, but to my knowledge, I mean, Facebook has filed an appeal against this. The matter is pending, and there have also been some judgments by the European Court, CJEU, also by Canadian Supreme Court, which are also problematic in some way. There were similar orders issued for global takedown of content. Yes, these are issues which could change the scenario of takedowns. I mean, over the years. Now, one issue that we also need to, initially when I mentioned the various issues, one is the initial stage of investigation. Second is in the stage of adjudication, and third is execution. Even execution, if you get an order from a court, if the party is located outside the jurisdiction, it's often very difficult to execute this order. That is where MLADs and other agreements with countries, with various, uh, let's say, conventions and all that would be helpful. So the problem that we have is with cybercrime, we have actors spread across the world. So even if you have an order from a court, how do you execute it is a problem, and that is where countries to work together. That is where treaties could be very helpful. Okay, thank you. Yeah, I think we are running out of time, so we also need to have some time for interaction.
So we have a few questions as well, if you would like to address them.
Okay, sure.
Yes, sir. So the first question is with respect to should India also become a part of the Budapest Convention, or shall initiate a new framework at the international level to address cyber offences?
Okay. See, the one, as I was explaining during the course of the presentation, this is a hotly debated topic whether we should be a part of Budapest Convention. There are definitely advantages to it because when you are dealing with countries across the world, it's always helpful to have, let's say, some kind of conventions, treaties in place. It's easier to, um, let's say, get when you are want some information from law enforcement agencies in other countries, entities, let's say, located in other countries. If you have a framework in place, it's always easier. So the problem with Budapest Convention is there are some clauses on intellectual property rights which are considered to be problematic for India.
So shall I move on to the second question that we have?
Enter it. So that is one reason we don't want to, let's say, sign the treaty. But yes, now that we have, with a lot of amendments which have happened to the Copyright Act, and that I think time has come to maybe take a relook and check whether it would be useful to, let's say, be a part of this treaty. Also, if you look at other frameworks, it is not that easy. If you see, treaty making process is a long drawn out process. So if to have like a completely new treaty, it's not going to be very easy. Yes, what we could do is try to get into some maybe MLATs with countries where you have more business transactions. Try to see if, let's say, how you can work with the US on the Cloud Act, because most of these intermediaries are based out of the US. Yeah,
Okay, sir. Shall I move on to the second question that we have? If there's nothing to
yeah,
add,
please.
certainly, sir. The second question that we have is what are the issues faced by the countries? This is with respect to the cross-border data requests. What are the issues faced by the countries when data required for investigation is stored at different locations and how to tackle these issues?
Yes. So again, uh, the way the various entities, various intermediaries operate. Now you have data spread across various jurisdictions. You have whether it's Amazon or whether it is Microsoft or Google or Facebook, you have their data spread across in various countries, and even hosting providers for that matter. So, uh, if you look at the transparency report that I showed, see, it is often easier if it's in the case of intermediaries like Google and Facebook to get data. Even there, the response that we get from investigation agencies is that often it's very difficult, even in the case of Google and Facebook, to get data. But these, because they have a presence in India at least, it is easier. But there are other entities who even don't have a presence in India. And that is where the treaties that I mentioned earlier, conventions, like the Budapest Conventions, provisions like Cloud Act, all these could be helpful. So it is, and one thing that we need to understand is with the kind of cloud structure that we have, this could be, let's say, hosted anywhere. And unless you have proper treaties, proper agreements with various countries, it becomes very difficult for law enforcement agencies.
Certainly,
There is
sir.
no easy answer to it.
Certainly. I think the next question is also an extension of the previous part and is based on the Mutual Legal Assistance Treaty. The question reads, as we see often, there is a delay in addressing the request made by other countries to provide the relevant information. What effective provisions do you think shall be mentioned in the Mutual Legal Assistance Treaty to make it an effective one as well?
So one, there should be like proper procedures in place with time limits as such. For example, if you have like a terrorist attack happen, you can't wait for days or weeks together to get information. Uh, let's say when the attack happened in the French newspaper, uh, they got information from Microsoft in, let's say, in a matter of few hours. So things like that can be very useful. So that is where when the MLATs, when the various agreements that you have should have provisions so that there is some kind of a time frame. If you are going to wait forever to get such information, then it's not going to help the investigative agency. So we also need to understand that they also face a real problem. Look at the investigation and the law enforcement agencies. They also often face a lot of problems in getting information. Yes, they have concern as far as in how these entities respond to such a request. That is something that needs to be addressed.
Certainly, sir. So the next question is also with respect to the investigation in respect of MLAT. The question reads, can there be a third party intervention when countries, both requesting and requested countries, don't comply with mutual legal assistance treaty, which in turn often delays the investigation? Can there be a third party intervention as well?
See, that again, when it is an agreement between two countries, it's very difficult to have like a third party come in between. So unless you have a framework in place, so that is where things like the Budapest Convention would be helpful because you have a proper framework in place where you have, it's not just restricted to two countries, you have a group of countries and a, let's say, institution which would be helpful.
Okay. Uh, the next question and the last one for the evening today is on a broader scale and sees the future of the cybercrime investigations in India. What reformation shall be done in India to make the investigation officers technologically efficient, as most of them, as most of the time, they lack technical training? Is there a requirement of annual meeting with other countries to share expertise skills with the officers? You know, it looks at the broader picture. What reformation steps that can be taken by the Indian populace or the Indian government in large?
So definitely, it is. See, it's always a cat and mouse game if you look at the criminals and the investigating agencies. So unless you keep pace with the technologies, unless you keep pace with what is happening across the world, it becomes very difficult. With new technologies coming up, you have, let's say, even the legal aspects for that matter, questions on jurisdiction for that matter. When you have things like blockchain coming up, I mean, where do you really draw the line? As you have data residing in various countries, which gets updated across the world. I'm talking about blockchain. So where exactly does the jurisdiction lie? Again, things like when you have new stuff coming up like AI, questions of liabilities, and there also you need to make sure that the investigating agencies really understand how all this works. So definitely this is a learning process, and you need to have proper training for given for the law enforcement agencies, even the judicial officers involved. Yes, definitely it's a complex process for sure, and a lot of
Yes.
challenges.
With this, we come to the end of the question and answer session. Now, I'd like to invite Dr. Kumaraswaran Pandey, Associate Professor of Manohar National Law University, and also he's the coordinator of the Center for Criminal Justice and Administration, and the editor-in-chief of the CCGA blog, to present the vote. Thanks to Mr. Prasanth Sugathan.
Thank you, Rhythm, for the opportunity, and a very good evening to one and all. At the very outset, of course, I must thank Mr. Prasanth for taking us very deep into a very complex, at the same time, very interesting issue of jurisdiction in cyber wrongs and cyber crimes, of course. And he explained, I guess, almost all the aspects involved in the jurisdiction. Not only talking about our domestic law, the municipal law, but also detailing the international legal framework in that regard. Mr. Prasanth, you spared your evening with us, and you enlightened the participants. I'm grateful for your very insightful talk on this very fascinating topic. I also thank our Honorable Vice Chancellor, Professor Dr. Subir K. Bhatnagar, who is the guiding force behind all academic endeavors that we take up, of course, under different banners, including the CCJA. I also thank the group of students that was the real brain behind the whole event. And I also thank the entire CCJA team for providing us with such opportunities. And last but not the least, I must thank the participants from different parts of the country for being with us. Thank you once again. Stay safe. Thank you, one and all.
Thank you, sir. With
Thank
this,
you
we
all.
come to the end of the session. The participants shall be getting their certificates via email. The team will provide the same. Thank you. Thank you. To be blessed.